Nikki? That's awesome. All right, guys, let's get started. Welcome to the Search and Seizure Show. This webinar is really designed to answer your questions, right? We get your questions, all the time. I love your questions. They make it enjoyable to be an instructor, all these different scenarios. So here's how we're going to do it. What I would like to do is go through the questions that I've gotten, right? Answer those, and then see if you have any questions. Now, during the webinar, if you have, questions, my mic a little close here. During the webinar, if you have questions that you want to ask, it's related to what I'm teaching or not, no problem. Ask it. All right? All right. Make sure you select everyone on the chat. If you do not select everyone, then nobody can see it except me, right? So Ed and a few others, do me a favor, just make sure that you change your chat settings to everyone so that everybody sees your chats and so forth. A quick introduction for those who are new here. If you're new here and you've never been here to one of my webinars, do me a favor, just say me. I'd like to see if there's some new peeps that do not know about Blue to Gold law enforcement training. My name is Anthony Bandiero. I'm an attorney and senior legal instructor. This is what I do for a living. I have the honor and the privilege to train cops all around the nation in search and seizure. It's a dream job, and I can't tell you how much I love what I do. Nikki is new, and I'm glad you're here. All right. So I was a full-time cop in Las Vegas. I retired early to go to law school in order to do just this. My purpose to go to law school wasn't to be, chasing ambulances and so forth. It was actually just to do search and seizure. So that's a little bit about me. Let's continue. I'm also the author of the best-selling Search and Seizure Survival Guide. I'm proud to say that it's tens of thousands of cops use this book on a consistent basis to learn the law, to understand what needs to be articulated in the reports, in the field, and so forth. And it goes along with our motto. Our motto is to get it right every time. Thanks, Chris. I appreciate it, right? Get it right every time. That is what our motto is all about. If I can keep you off CNN, if I can keep you out of needless court battles, and if I can help you catch the criminals, but do it constitutionally and respect everybody's rights, then we all win, right? And that's what that book is for. There are state versions of that book, but the national version is really applicable to everybody. Disclaimers: laws and agency SOPs may be more restrictive. Guys, especially with some of the questions that I got this week, just realize that states are always allowed to be more restrictive. They can be more restrictive under their own case law, state law, policies, and so forth. I'm going to teach you what I think that the law is looking for, especially when it comes to the Constitution. I'm not an expert in everything, all your statutes, right? Illinois, New Mexico, New York, that's not my specialty. My specialty is search and seizure, the Constitution, right? If you have any doubts about the legality of your actions, push it up the chain. You got to get your questions answered in 2021 and beyond. And finally, this course is legal education, not legal advice. I cannot give you legal advice, and I will not give you legal advice over this medium. That would not be appropriate, right? This is there's a lot of people on this. A lot of people are going to watch this later. This is not about giving you legal advice. It's just about giving you my opinion about what I think the law is looking for, and also making good case law. We're going to email your certificate. If you signed up for this through Zoom, you're going to get a cert. If you watch this on YouTube, it doesn't have a cert. You have to actually attend the live versions. If you want to attend those in the future, go to bluetogold.com and you'll see an icon for free training, right? Just click on that and you can sign up for the next one. And all of our live classes come with a certificate. Okay, so in the future, if you want me to answer your question, right, and it's a search and seizure related question, go to bluetogold.com/show and it'll just have you fill out some stuff. It'll come directly to me, and I'll include it either here or I'll turn it into a YouTube question. So how we're going to do this, I'm going to answer some questions. I'm going to open a forum. I'll open up the forum. If you have any questions, please, that's the time to ask it. I prefer that you ask on the microphone. There's no camera, just so you know, let's get that out of the way. I cannot see you and I cannot hear you. But if you do want to ask a question, I prefer that we turn on the mic and let's ask it over the Zoom. All right. So submitted questions. I have, I think, 5 questions that I'm going to answer. The rest of them I already answered on YouTube. Question number 1. Can I search or seize an unattended cooler or container that I believe contains food items? All right. Now, this one is a little interesting, and I had to do some research on this one. So let's go through it. So I got my little pages right here. So this is a federal officer. And by the way, if you want to send out, thank you, Kim and Joel. If you guys want to send out your, and Mike too, your agency and state to fellow officers, please do that. Normally I do that, but I forgot to put that slide in here. So send out to fellow officers. We got Maryland State Trooper retired here, Utah, New Mexico, South Dakota, California. Keep sending out. Awesome. So the officer says, again, this is a National Park Service officer, right? I work in Glacier National Park as a federal law enforcement officer. Primarily due to bears, our superintendent has required that unattended food items or containers with food be kept in a sealed vehicle or in a bear-proof container in a campground. That just makes sense. This is authorized under 36 CFR 2.10 subsection D. And it says equipment used to cook or store food must be kept sealed in a vehicle or in a camping unit that's constructed of solid, non-pliable material. Many of my coworkers believe it is acceptable to search and seize coolers or other containers that they have reasonable suspicion contain food from vehicle racks, truck beds, and left out in campsites. It seems to me that probable cause would be articulated for the coolers that they contain food items, but generic tote containers seem like a stretch. Even so, it seems to me that we could seize them, but not necessarily search them without an exception to the search warrant requirement. Also, does the Carroll Doctrine come into play with these containers found on vehicles? All right. So this is a great question. Let me just kind of ask you guys real quick, and we got some experts here. Just what is your gut telling you here? What's your intuition? Even if you don't work in this area of the law, right? If you're a park ranger, BLM, insert wildlife, whatever, and you are in charge of, enforcing these laws, what do you think? Do you think that it's reasonable if somebody leaves out a container that does not seem to be tamper-proof by the bears? Do you think that you can open it and seize the food inside, or not? Andrew says, okay, to take the cooler, but not to look inside. Bill is probably saying, Bill, are you leaning towards opening it under some kind of rationale? I got you. Just only if it's left out. Okay. Ed says open it to also identify the owner and so forth. Tyler says cooler, yes, as it likely contains food. The other containers, I think you need some other type of nexus to the food item being inside. Okay, I'm actually I like all these all this feedback. I think we're on the right track here. So here is, let's kind of go through this, right? So I gave you the facts. Can we do this? And let's continue. All right, actually, one second. Okay, so here is what the CFR says. It says food storage, and I gave you a snippet of this, but let's read it in full. The superintendent may designate all or a portion of a park area where food, lawfully taken fish or wildlife, garbage, and equipment used to cook or store food must be kept sealed in a vehicle or in a camping unit that is constructed of solid, non-pliable material, or suspended at least 10 feet above the ground and 4 feet horizontally from a post, tree trunk, or other object, or shall be stored or otherwise designated. Violation of this restriction is prohibited. So this is a law, right? This restriction does not apply to food that is being transported, consumed, or prepared for consumption, right? And somebody on the YouTube channel says, what does Yogi say, right? That's a very good question. So one thing I could not find is an answer, right? A direct answer based off of case law. The CFR, definitely doesn't say anything about this. What do you do? And when I looked at all of the cases that have even referenced this particular subsection or this actually CFR, there's just one. There's just one case that I can find, and it has to do with some defense, right? About sleeping in a truck or something. I mean, it has nothing to do with our conversation, but there really is nothing out there. And then when I also looked at the citing resources, again, it was almost completely barren. The landscape is barren. So here is the bad news. The bad news is that we are definitely making case law in this, right? What, in the sense of you are on your own out there. You're in the wilderness of case law. You see that? You're in the wilderness of case law. However, I do think that opening the container is lawful if the ranger had probable cause. It was violating the CFR and wanted to make sure that no food items were inside. This would fall under exigency. If we see a food type container and it's made of pliable material, and the officer wants to make sure, just wants to check to see what kind of food items are in here, I do believe that would be lawful. I would, if I was out there, that's what I would do, because the alternative is a little extreme. In other words, what is the alternative? The alternative is to require this officer to take all of these damn containers back to the station, apply for a warrant, and then open them. I think the better view is, it sounds reasonable that if the person has left these containers out, and you might say abandonment, but I'm not sure abandonment works here, because the person would still have a reasonable expectation of privacy in the containers if you believe that that's their campsite. So I'm not going to go with abandonment here. I'm going to go with that this is a warrantless search based on probable cause, because you believe that they're violating the CFR, and the most reasonable thing to do is to open it and seize the food, or the container as well if you want to at that point, but to seize the food under the exigency of the circumstances, that the bears don't come out and actually try to grab the food. That's what I would do. Reasonable suspicion. Okay, there is an argument that reasonable suspicion can work if you have regulatory enforcement. The problem with using reasonable suspicion as a standard here is that normally the courts would want the person, the citizen, to be on notice that type of search can be done as a matter of routine with just reasonable suspicion. The CFR doesn't say that. Now, if there's somewhere else that I'm not seeing that it says, campers beware, your food containers can be searched, as a matter of routine, just to make sure there's no food in there. And if it's not in that bear-proof container, if it says that, then that's a different story. But I don't have any facts that say that campers are put on notice that these containers can be searched. So I'm going to use the regular rules, which is probable cause, and I think exigency applies here. The last thing I want to say is, okay, what about the non-food containers? Well, here's what I would say. I would search the food containers first, the igloos, and see if they have food. And if they do, and there's other things out, then I think you have probable cause. That's the other containers. But if you search them first and it doesn't look like it's a food container, let's say it is, well, a lot of these containers will be like food. They'll be, maybe Yeti kind of coolers and stuff like that. But if you search, backpack, great, let's a backpack. You search a backpack first, and you have no probable cause that food can be in there, and you find, insert the blank, narcotics, firearm, whatever. I think you got a problem on your hands. I think it's going to be suppressed. That's what I would do if I was the judge based off of these facts. Let's continue. Question number 2. Are police liable if a drunk and trespass casino patron leaves and gets hit by a car? So the police are on scene and they help kick the person out, right? The person gets trespassed. The person is intoxicated, let's say highly intoxicated, and lo and behold, they walk into the middle of the street and get ran over by a car. Based off of these facts, are police liable? Yes or no? And maybe tell me why. So we got 2 yeses. Humberto, do me a favor. Change your chat settings to all attendees, or I'm sorry, to everyone. Ed says yes, duty to protect. Everybody's saying yes so far. Let's say Jennifer says if they were not able to care for themselves, they should have been taken to detox, right? Let's say, yeah, I'm with Andrew here. Andrew says it depends on the level of intoxication. Were they still able to care for themselves? Let's say the answer is yes. Let's say that they're intoxicated, they're drunk, but they're not so drunk that you would have to take them to civil custody. They are intoxicated, but they are walking, talking. They don't want a ride home. They say they can walk to their house, whatever. You guys still, and if something happens to them, they get hit by a car. Jennifer then says no. How about you other guys? Does that change anybody else's opinion? What about Just a Bill 02 on YouTube? So Catherine, what's up, Catherine? Long time no see. Happy holidays. Catherine says, no, you don't have a constitutional right to for protection by law enforcement. Generally, that's the rule right there. So let's talk about the issues, right? So let's read through it here. This is from an officer in Arizona, right? Same state as you, Catherine. So, all right. So the officer from Arizona says he works for an agency in Scottsdale, and they respond to a casino call where security often calls us to help remove intoxicated subjects refusing to leave. Most of the time, these subjects are on foot and are uncooperative with the police. Are we liable if we just let them walk away, highly intoxicated, into the public roadway from a casino property and something happens to them? If things work out, we try to give them a ride, find them an Uber, or arrest them for trespassing. We often get into the use of force situations because they are uncooperative after multiple requests to leave. I also understand that we can probably arrest them for the public intox or the public nuisance or the trespass, but sometimes we just let them walk. All right. The answer is that, generally speaking, there is no requirement to protect them, right? Here's what the Supreme Court or the Ninth Circuit has said, but it's based off of the Supreme Court. The due process clause, you guys hear those? The dogs are going crazy. All right. The due process clause is a limitation on state action and is not a guarantee of certain minimal safety, minimum levels of safety and security. Simply failing to prevent acts of a private party is insufficient to establish liability. The general rule is that the state is not liable for its omissions, meaning failing to protect. And the due process clause does not impose a duty on the state to protect individuals from third-party harm, right? So generally speaking, there is no liability. There can be liability with 2 exceptions. There are 2 exceptions to this general rule. First, a special relationship between the plaintiff and the state may give rise to a constitutional duty to protect. What's up, Sean? Hold on 1 second. So here are the 2. So wait, somebody's texting me real quick. Hold on. answering a question on the chat. Okay. So, so Sean and Brian have taken the certified search and seizure instructor class that we just had last week. So was that a good class? Did you guys enjoy that class? Hopefully you did. I know the YouTube peeps. Good. I'm glad you guys liked that class. All right. So here are the two exceptions to this rule to duty to protect. Number one is a special relationship. And number two, affirmative police conduct that and foreseeable harm. That is how, generally speaking, you can be liable for duty to protect. But I just want you got to know something, that generally speaking, even if you could have done something, even if you could have prevented harm, property damage, theft, and so forth, you're not liable unless A, that victim has a special relationship with police, or you did something to cause that. So when you see police officers, watching a crime occur, let's say watching looting, and there's 100 looters and there's only 5 officers on scene, and they are not prepared to take action. They don't have enough resources. The supervisor is, saying stand by, stand back, and something happens. People get hurt. People steal property. They vandalize property. If the shopkeeper or the victim who's physically injured sues police, are they going to win? And the answer is absolutely not on those facts. Absolutely not on those facts. So, you got to do something. Okay. 1 second. All right. So let me give you some examples here. Victim was assaulted and told police he did not want medical attention, despite being told by police he should seek it. Officers helped him get back to the hotel, where he was found 2 days later with permanent brain damage. Should the police be liable here? Right? The guy refuses medical attention. There's nothing necessarily, right, showing that he's going to die or has brain damage. It's all internal, right? Okay. Exactly. Tyler says he was not the one in custody. Good. So this is, first of all, is there a special relationship? The answer is no, right? And two, did the police do something to cause that guy's harm? The answer is no. They didn't hurt him. They didn't use force against him. He wasn't detained. He was the victim here. They gave him a ride home, but this is not affirmative police conduct and so forth. Sean says, Sean, hopefully next time, Sean, is that supposed to go to everybody? But I'm going to read what you said. Oh, should I not read it then? Okay. Okay, now I can. All right. So what are your thoughts on mental injunctions and their lack of due process? 2 people can swear out in front of a judge, that their person needs a mental hold, right? I know you guys call them injunctions, but we call them these holds, right? Okay. They sign it. We have to go and grab them for a 3-day hold. Okay. Just think about due process. Now, if the judge, now you're saying the judge signed this, right? Though, Sean, in your situation, somebody swore out an affidavit and the judge signed it, or the court issued this, or then that is the due process. I mean, that is due process. It's not full due process. It's ex parte, right? It's ex parte. It's only one party is in court, right? The people who believe that this other person needs, but the due process in this sense is the judge. The judge is supposed to weigh the evidence, right? However, I think a more poignant question for cops today is, what about the mental holds with the warrantless ones, where the cops are making the decisions to do a 3-day hold, a 72-hour hold, whatever, and the person is saying, I don't want to go in. I'm not going to hurt myself. Yes, I said something. I said things that, I was suicidal. Yes, I did tell my girlfriend that I was going to kill myself if she broke up with me. Yes, I said that. But however, I've calmed down. I'm okay. I'm not going to do that. I just want to be left alone. What about those situations? I think those ones are the tougher cases. And I think that, quite frankly, if I can be candid, I think that police oversees people in these circumstances where the person does not really appear to be an imminent and immediate threat right now, right? And Andrew, I think that we have to be careful with those ones. Again, the standard usually is, imminent or immediate harm to themselves or others, which is like imminent or immediate. If they look like they've calmed down and they're telling you that they don't want to go, I would just be careful with that one. And another officer says, I'm still not taking that liability on myself. I hear you. Totally hear you. Okay. No liability to the officer did not take the victim in custody and did not prevent aid. So Sean says, I don't agree with that. I think we need to get a better person to make that judgment. But you're talking about the cop is making the judgment about taking them against their will when there may not be imminent or immediate risk of harm to themselves or others. That's a constitutional question. And I just don't know. I see a lot of over the tensions on these sentences, in my opinion. I see that cops err on the side of caution, which is fine, but they have rights too. Oh, I agree with you. Okay. Right. These people have rights too. And it also can have long-term consequences for them, being, and Greg asked a great question, right? There's more facts, right, Greg? I have not given remotely enough facts to make a decision for a particular circumstance, but I do want cops to be aware that does implicate the Fourth Amendment. And we do want to, make sure that their rights are also taken into consideration. In a bizarre case in the extreme, police detained a naked and beaten minor during an investigation. They then released him to his assailant, Jeffrey Dahmer. Now, this is before they knew that it was the Jeffrey Dahmer, right? This kid was naked, bleeding. He actually had a hole in his head. Jeffrey comes over. He was at the bar. The guy Jeffrey put this guy to sleep with a poison, and the kid woke up out of it and escaped the apartment while Jeffrey was drinking at the bar. He was going to kill him that night. The police then did not do a thorough investigation and gave the kid back to Jeffrey and thought this was a lover's quarrel. Jeffrey then killed the kid. Can the police be liable in that sense? Did they do something? Did they do something affirmative that can cause future harm, right? In that case, right? Yeah, exactly. You know the answer on that one. So the kid was only, I think, 13 years old. How did that one slip by? I don't know. How did they not realize that this kid, they actually said in the report that the kid was an adult. I don't get that one, right? The kid's a 13-year-old kid, and they returned them back to Jeffrey. So here's from the case, and the court found that a special relationship existed and the parents could sue the police. Police did not arrest a husband okay, now check out this case. So the wife and the husband are going through, a separation, right? And the wife gets a temporary protective order, a TPO. So they let the husband go first, leave the courthouse, right? Get out of here, leave. And they also know that he has a warrant for his arrest, but they don't serve the warrant. Why? I don't know. Maybe, this is pre-COVID, but, maybe if you look at it today, a reason for COVID, we can't arrest on this situation. We don't have room in the jail. Whatever it is, they're going to release this guy. He then goes to his car, grabs a knife. The wife comes out of the courthouse and he stabs her to death, including their unborn child. The estate, the family of the wife, sues the police because if they would have arrested him, they would have prevented this. So the question for you is, can or should, based off what I told you, should the police be liable for this murder? Yes or no? Okay, yes. Sean says no, there's no duty to protect. Yes. Tyler says no, there's no special relationship. Yeah. Andrew says you're playing the what if game. Andrew is making a good point, right? There's something that always could happen, right, Andrew? You know, Nikki says yes with a question mark. Okay, and Catherine says no. The answer is no, right? Exactly. So, yeah, and my friend on YouTube also says no, right? And the answer is no. This is a very, very sad, tragic case. Yes, it's true that if they would have arrested him, then nothing bad would have happened. That's the what if game that Andrew's talking about. But you can do what ifs all day long with a lot of your stuff. What if a guy, you know, that's speeding or driving recklessly gets a citation and continues to drive recklessly and kill somebody? What if? But in order for the cops to be liable, it has to be something affirmative, that you do something to cause this, right? Like you give the guy back his knife if you seized it in the courthouse. That might be one factor, but also don't forget the other factor. It has to be foreseeable. If the cops knew that this guy made claims he was going to kill his wife after this, you know, if he said something like that during the hearing and they somehow did something to, you know, cause that, then that's different. But here they didn't, it wasn't foreseeable this guy would go crazy like this, you know, and kill his wife and so forth. So the answer is no. Police investigated a domestic violence involving an off-duty officer. Always very, very challenging situations. You got to do your job. Now, allegedly, the officers told the suspect that the victim deserved the abuse and refused to make an arrest despite probable cause. The abuse continued. Can the victim sue the police that did not arrest in this case? All right, everybody is saying yes. That's correct. Police helped create the danger by praising the abuser and refusing to make an arrest. That is affirmative conduct, right? And Katie's like, absolutely. That's affirmative conduct, and it's foreseeable that the abuse would continue. That is liability. I know you're thinking too, oh, but Anthony, it's also a shell arrest. That is not a constitutional issue. Shell arrest versus non-shell arrest. That just means you're violating the statute. You can get disciplined, you can get in trouble by the court, but that doesn't necessarily mean that the Constitution requires the arrest. But here, it's a duty to protect because it's affirmative. Police ejected, I don't have the case citation on this, but I remember this case distinctly. Police ejected an unruly patron from the bar during the winter. He's acting a fool, right? He's causing disturbance and they want him out of there. Now he says, can I go get my jacket, right? And can I get my jacket? And the police said, you know what? You've overstayed your welcome. Get out of here, right? And the guy ended up freezing to death in an alley. Did the police do something affirmative that caused foreseeable harm? Tyler says no, not foreseeable not the death was not foreseeable. Right? Let's say, Tyler, it's a really, really cold, it's freezing outside. Tyler, it's absolutely, it's not just winter, but it's freezing outside. Andrew says, and I'm reading this because my YouTubers can't see these, right? You can't see these chats, right, YouTube? Okay, so Andrew says, okay, they should have provided his belongings back to him. That being said, though, he could have still frozen to death with the jacket. However, you know, that I think you're right. I think that if he could have still froze to death, but did they do something affirmative that at least helped create his peril? And the answer is yes, right? So this one's going to be liability, right? Even still, if they knew he lived close, had a ride, etc. However, if they knew he was homeless, no ride, Yeah. These are very basic facts, but the point is that police made the wrong decision here. Somebody on YouTube says, I thought there was a concept that an officer is always on duty. The answer is that is not that's not strictly true. What it means is that police have the authority to put themselves on duty at any time. If they see a shoplifter and they're off duty, they can, if they want to, okay, there's no public link for the comments, unfortunately, but there is this concept that cops can put themselves on duty anytime they want, right? They have the authority to become a police officer at any time when they're off duty. However, just because you're a police officer and you're off duty does not necessarily mean everything you do was police related. And my friend Sean says, correct. Otherwise, you need some serious back pay, right? Okay, another YouTube comment. Responding to a two-way welfare check. What's a two-way? You mean like Second Amendment? What's a two-way? Known drug house with occupants of active warrants and vehicles backed into the driveway. Can I check the plate's VINs to identify who may be home prior to the door approach? And the answer is yes. I'll just explain to what do you mean by two-way, what that means. That's probably some code that's used at your agency I'm not familiar with. But if you have a legitimate reason to be on the premises and you want to see, who else is there that could be a danger to you and so forth, I see no problem there. However, if you have no reason to be on the property, right? If you have no reason to be on the property, welfare check, domestic, it's 2 o'clock in the morning. Okay, I'm sorry, I got it now. So basically 2 ways to check the welfare. I think you should be fine. So here's the takeaway, right? If the patron was detained by police, this is going back to the casino, right? The original thing came from the casino, so I added in these extra cases. If the patron was detained by police and it was foreseeable that he would get injured, right? He was so intoxicated that he could not walk straight. He could not stay on the sidewalk. Then there may be liability. However, right, a possibility is not automatically foreseeable. I think it was, as Andrew said, we can do what ifs forever. What ifs won't get you there. It has to be foreseeable. A reasonable person would have foreseen that this guy was going to walk into traffic, likely could have walked into traffic and got hurt. Okay. Question number 3. Do police have to hand over a person's ID to security if they want to trespass the patron? So this is also from our officer in Arizona. So again, officers respond to calls for service at the casino, and the guy is being trespassed, right? Oftentimes, the officers will hand over the casino security, the ID to the security for them to take the information down. Now, the officer doesn't like that. He thinks that this is a little, pushing it. Most of the time, this happens because the casino security just asks the officer for the ID so that they can trespass the subject and to complete their report. If a crime occurs in the casino property, do we have to provide security to the arrestees, patrons, witnesses, IDs, or should we just give them the first and last name? How much privacy do they have with their IDs at the casino? All right, so let's look here. So Andrew says, no, they can verbally provide the info, right? Let's see what YouTube says. So just a brief detention created by a special relationship in the casino incidents. Okay, so what do you guys think? If the casino, imagine this situation. The patron is saying, I do not want them to have my ID, right? I don't want them to have my ID. But what's the alternative? Should you at least still can you give the security at least the name and maybe a date of birth? What about that? What about just not handing over, but giving a name and date of birth? Yeah, and my friend on YouTube says, I don't believe police need to handle the ID to security. They just need to address it. They don't need the address or other info for the trespass. Okay, so it looks like It looks like we're half and half. 2 people say no, and 2 people say, oh no, I'm sorry. Now it's Tyler does say yes. I think that's fine. Okay. So here's what trespass says in Arizona, right? This is very similar to a lot of states. It says a person commits criminal trespass in the 3rd degree by knowingly entering or remaining unlawfully on any real property after a reasonable request to leave by a law enforcement officer, the owner, right, the casino, or any other person having lawful control over such property, like an employee, or a reasonable notice prohibiting entry, right? No trespassing on this particular area. Clearly, the law does not give the answer to the question. It does not say that the proprietor of the private establishment can demand the person's ID. So how are we going to handle this? Now, one, if the person, the one way to handle this is that if the person actually committed a criminal trespass, they have been warned to leave and they don't leave. Well, that's criminal trespass. But what about the situation where the person has been warned to leave, they want to leave, but the business wants to get their information, so they want to get their information so that they can criminally trespass them in the future if they come back. Okay, here's my advice. I would not hand over an ID if the person objects. Now, I've done this before when I was a cop, give the ID to the casino and they write down information. I've never really thought about it really more than just that. But now that my cop asked this question, I think it's a good question, especially if the person objects. If the person objects, I would not hand over the ID. I think that the person, on YouTube is saying that there's extra information on these IDs that they don't need to have. They don't need to have addresses. They don't need to have ID, OLN numbers, the license number, and so forth. Maybe even their social security numbers on some licenses. I know social security numbers were on older Nevada licenses, but obviously no more. I don't think social security numbers are on any new license, but I could be wrong if you have a different, But the point is I think it would be reasonable to at least give the business the name and maybe even the date of birth. Hell, even if you're uncomfortable giving the full date of birth for identity theft, give them the year, okay? I think that giving the name and the year of birth is enough for them to write down the report that if this person comes back, we already ejected him. He was warned not to come back. Also, don't forget that you can take a picture of this guy, right? The business can take a picture. There'll be no constitutional issue there. And Jesse also says that the businesses can call the police records and get a copy of the report the next day if a report was made. I don't know if even reports can be made in these cases, right? And Jennifer says you can find most of that info on Google. That's absolutely true. So that's my suggestion. I don't even know if this is even a constitutional question, right? I mean, the guy, even if the cop handed over the ID, is that a constitutional issue? Probably not. I mean, what are you going to claim under the Fourth Amendment? That he seized my information, that I have an expectation of privacy in the DL info? Maybe, maybe not. I looked, I found no cases on this. However, I understand the question, and I do think in 2021 and beyond, we should be careful with giving other people personal information that could lead to identity theft, that could lead to harassment and so forth, right? Jennifer says, don't you have to show your ID to get in? Well, not really. I mean, if the guy looks like he's 60 years old, I don't think anybody might ask him. I mean, most casinos in Vegas are not asking you for your ID to get in. So if you did have to show your ID to get in, that'd even be better for our argument, wouldn't it, Jennifer? That'd be a great part, like even a slam dunk, like, hey, you had to show when you got in. Here's the ID again. Chris on YouTube says, second part of the previous question. If you're lawfully on a driveway, again, this is how these shows work, right? We're kind of going back and forth on different search and seizure issues. But if you're lawfully on a driveway and observe a stolen license plate, can I remove the plate without a warrant? Occupants of the home are not answering the door. If the driveway is on curtilage, which it probably is, you should not be doing that. Now, what happens if you remove the license plate and you don't charge anybody? Well, I guess it's no harm, no foul, because you're not going to charge anybody with a crime. Nobody's likely going to sue you on entering their curtilage to take this license plate back, right? They have no privacy interest in a license plate and they have no harm. However, if you charge them with a crime, especially if the car was stolen, that would violate Collins v. Virginia, U.S. Supreme Court, where cops are not allowed to go on a person's curtilage because of a stolen property like a motorcycle, license plate, and so forth. So that's the answer to your question. Question number 4. Can you search a driver and a passenger based on the smell and observation of marijuana? All right. So let's go to this one. Okay, this is from a cop from Illinois. See if he's here. No, he's not here. Okay. So here's the cop in Illinois. So he says, after smelling, observing marijuana in a vehicle on a traffic stop, you have the driver and the passengers exit the vehicle to search it. Can you also search the driver and the passengers based on the smell and the observation of marijuana, or do you need a separate PC to search the driver and passenger? A little bit more context. So you stop a car. That's the question. So here's some background. You stop a car, and as you approach the car, you can smell a strong odor of burnt cannabis. You ask the driver if they have marijuana, and he shows you a small amount in a baggie. You tell the driver you're going to search the vehicle based on his admission, the smell, and the observation. You have the driver and the passengers exit the vehicle and walk to the rear of the vehicle on the sidewalk. Can you search the driver and the passengers for marijuana, or would you need a separate PC to search the passenger? Also, can you, can the driver and the passengers be considered a container in the vehicle? Okay. So let's go here. So separate PC. Sean says separate PC for the passenger. Brad says driver, yes. Passenger, not necessarily. Would need more articulation. And you call for a canine and operate off of that. Bill says ask for consent. Paul says search away. Right? On the YouTube, it says smell of marijuana would be state dependent. Yes, but this is also smoking burnt marijuana in a car. That's going to be pretty universal there, smoking and driving. Tyler says separate PC for the people, but also separate PC for the person, for the passengers especially, but also burnt marijuana implies that the evidence is gone. Yes, but there may be something left over. What is that? What is that piece of evidence, Tyler? Yeah, okay, the marijuana may be gone, but what else could be left? The paraphernalia, yeah. Okay, let's go through this. Now, generally, you cannot automatically search passengers when you have probable cause to search the car. Instead, you need PC as to them. So that's our first fundamental rule, right? Do you have PC as to them? This is an idea that's been around for a very long time, right? We see no ground for expanding the ruling in the Carroll case. That's Carroll versus United States. That is the searching of the car, right? Which is probable cause, no warrant. In the Carroll case, to justify this arrest and search as incident to the search of a car. We are not convinced that a person, by mere presence in a suspected car, loses immunities, meaning the right to be left alone, from search of his person to which he would otherwise be entitled. Warrantless searches of passengers usually requires that there's a nexus between the contraband and the passenger. That's going to be the hard part. We have to get that first. And then there's a warrant exception. That's easy. There's exigency. There could be, search incident to arrest. I don't think you have to worry about that part. If you can get the connection between the evidence and the passenger, you should win your case. So here's an example from Maryland. A drug dog alerted to the driver's side of the vehicle. The driver was the sole occupant and searched. Does that sound like there's a nexus between the evidence and that sole occupant, right? What do you guys think? And on YouTube, it says, if the driver, if the passenger, let's say the passenger was smoking, would it be illegal for them to smoke? The answer is absolutely. I know of no state where you can smoke in a car and drive, whether it's the passenger or the driver, right? There was probable cause to search the lone occupant and driver. However, what is best practice? The best practice is to search the car first, see what evidence is in there, and then go for the driver. It's just a little easier, especially if you want to do like a process of elimination. Then you got the nexus. Or you find the evidence in the car, and now you can do a search incident to arrest. That's also cleaner. Yep, exactly. A drug dog alerted with multiple occupants. When no narcotics were found, the cops searched all occupants. Do you like where this is going? Sean says nope. Unlawful search. You got to have the nexus, right? Now, who is probably not going to be the issue? Which occupant in that vehicle is probably not going to be the issue? The driver, right? The driver. Drivers are usually searchable because they're presumed to have, dominion and control over the contraband. So I don't see a lot of cases with the driver. It's all about these passengers, right? And Tyler also brings a good point. Where did the dog alert? We affirm that a positive canine scan, right, sniff, whatever, to a vehicle's interior compartment, generally without more, does not rise to probable cause to search all passengers of that vehicle. That's not the rule. You got to have nexus. Remember, you need a nexus. What would you tell a judge why you want to search the passenger? If you don't know, don't search. If all you're going to tell the judge is, Your Honor, they were in the car, weren't they? That is not a nexus. That is not going to work. I would not search the car based on those facts. Sean says, why? Because what famous case was that articulation? Arizona versus Gant, right? Not to throw my Arizonians under the bus, but sometimes my Arizonians make some pretty bad case law, okay? Do we have to bring up Miranda, anybody? But in Arizona versus Gant, my Tucson officer, I believe it was Tucson, right, said, why did you search Gant's car even though you arrested him for no license and a warrant? And he said, quote, because the law says we can. Exactly, Matthew. Freaking guy. Hey, this guy's talk about making bad case law. All right, Nicholas says, isn't there a decision that if all occupants deny ownership, they can all be arrested and charged? Okay, there is a case. Who can remind me of that case? It's isn't it Schlenkloff? Schlenkloff. I can't remember exactly how, but it starts with an S. Yeah, Sloth something, right? Thank you, Sean, for at least you can't say it either. I forget that it's like Schlenkloff, but the point is that was a case about constructive possession. And and that was a search incident to arrest. That could be a search incident to arrest. That case doesn't answer the question, can you just search them based on probable cause alone? That was more of an arrest. So it doesn't quite answer what we're doing here. Like when we go to court and the court asks you, why'd you put hands on this person? And you say, because I'm searching for evidence. You need nexus. And if the cop says, because Your Honor, I found evidence in the car and now I'm going to arrest everybody because I believe they are involved in it. That is constructive possession. Does that make sense? There's a difference right there. All right, cool. Cops smelled the odor of marijuana and arrested the 4 suspects. Again, now this is a case from Illinois, which our officer is from Illinois, right? But it's a Fourth Amendment case. It applies to everybody. But, right? Doesn't that sound right? Doesn't that sound like we're in the same boat? Just because you smell marijuana, especially raw marijuana, is not necessarily enough to search the passengers. Why do you think that they're in on it? In effect, the defendant's arrest, this is the passenger, was prompted by a mere suspicion that someone must have been smoking marijuana, and therefore the best thing to do was to arrest and search everybody. That is not the rule. So let's go through a couple of things before we move on. One is Illinois does have a law that says that marijuana has to be transported in an odor-proof container. I love that law. I mean, I wish all states had that. Illinois is the only state that I know that does have that. And also there's a law about it has to be in its original packaging. So basically, if I got this correct, and my Illinois cops can correct me if I'm wrong, but basically Illinois wants you to buy the recreational use marijuana, at the dispensary, keep it in its container, bring it to the home, and then smoke it at home. That's to me really what the intent of the law is. Whereas other states like New Jersey and California, Nevada, and all these other recreational states, you can actually have raw marijuana on your person and not even in its original container, and that in of itself is not a violation. Also the burnt issue, right? Sean is, you talking about Sean, you talking about New Jersey? What are you talking about? No, Sean. No, Illinois. You're talking about Illinois. So the other issue is burnt marijuana. I've seen cases now cops articulate that. Why do you believe that they were smoking while driving? Not just going to court and saying, Your Honor, I smelled the odor of burnt marijuana. And the defense attorney would say, well, do you have any facts or circumstances they smoke while they were driving, like recently, or just that they smoked in the past? And the cop is not able to articulate that they were smoking while driving in this instance. And they lose the case because it may not be illegal to pull your car into the garage or whatever and smoke that joint in your garage inside that car. Maybe the kid is living at home and he doesn't want the parents to, I don't know. I mean, it could be 1,000 reasons why people want to do that and not smoke in their house. But, that's the point. Cops smelled marijuana and saw smoke coming out of the vehicle. Can they now search the passengers? Thanks, Chris, on YouTube. That's awesome. Right? Okay. The answer is yes, right? Lawful arrest, because now you have the probable cause that they're all in on it. If, even if the passenger is not truly smoking and they don't like to smoke marijuana, if they're going to be in a car and everybody's going to be huffing and puffing in that car, that's a fair probability, that's probable cause that they're in on it. The constable's actions were based not on the smell of burning marijuana alone, but on the contemporaneous presence of smoke coming out of the car. That's just, again, we're good to go. Nexus factors. Where did the dog alert? It does help, right? Somebody brought that up. Where did the dog alert? Guilty mind evidence. The passenger is overly nervous and is trying to, get away from the traffic stop and is trying to leave. Deception. The passenger is lying. Abnormally nervous, right? Prior history. They have a drug history. They got picked up for paraphernalia 2 months ago. They're on paper for some drug crime. Plain view observations. I got something that's, if the drugs are in plain view, the passenger has some explaining to do. What about searching containers attached to the person, like a wallet or a fanny pack? Did those fall under the motor vehicle exception? Just to answer the question, my cop says, do people fall under the motor vehicle? Are they containers? The answer is no. What about their fanny packs that are attached to them? What about the person's wallet in their pocket? Are those containers for the under motor vehicle exception? Okay, looks like yes. Tyler says not if they are not if they're still attached to the person, right? Is that what you're saying? If they are still attached to the person, okay? What else, guys? There's a lot of people in here. I mean, Tyler says okay. Sean says I agree with Tyler. If it's still attached to the person, it's not a container under the motor vehicle exception. All right, that is correct. Yep, correct. Like a purse. A purse is a container, right? It's just a shoulder strap. A purse is a container. A wallet and a fanny pack, interesting enough, it's not. In order to search a container under the automobile exception, right, it must be sitting on its own inside the vehicle. And essentially, it must be independent of the person. If it's physically attached in the fanny pack, it was a case, then it's not a container. Then you have to have probable cause as to them. But the backpacks, the purses, usually it is off their person. I don't have a case where the purse or the backpack was still attached to the person. However, I would lean on the side that if you have probable cause for the car and they're simply just wearing a backpack and it can come off easily, I would just probably search it. That's what I would do. Or a better way to do it actually is just to go through the car, keep the backpack, take the backpack off, and search the car first and find and look for evidence where the guy was sitting, and then even build up a better case. But I do think that the backpack is sitting on its own, whereas the fanny pack is a little just different in kind. I don't know, but we're making case law there. Yeah. People are not containers, is what my YouTube friend said. So somebody on YouTube says, what about a small locked box that nobody admits possession to? Well, you actually have a different form. You have, not only do you have probable cause, first of all, it's a container. It is a container. If you have probable cause for it, but now you also have another doctrine that's going to enter the mix. What is that, Sean, and my other search and seizure instructors? If nobody's admitting, they say, do you have anything to do with this? And the person's like, I don't know what that is. Then you have abandonment. All right, so you have abandonment. If the object is abandoned by that defendant, if the passenger says, I have nothing to do with that lockbox, and the cops open it and they find contraband, plus they can tie the passenger to it, IDs inside of it, other personal property that belongs to that passenger's inside of it, then the passenger can be charged because his rights weren't implicated when the item was searched. On YouTube, it says, what about the single purpose container doctrine? No, because a single purpose container announces its contents in a way that only contraband is inside. These are your bricks. These are your balloons that are filled with drugs. These are your things like that. A Crown Royal bag, a safe. Those things are not single purpose containers because they can hold other things, right? Right. Duct tape block, all those kind of things. Question 5, and our last question. If you have other questions for me, we'll have some time at the end. Hopefully you do. I love to turn on the mic. I think that's kind of what my intent when I started these search and seizure shows was actually people to ask questions live. But we'll see if you guys have some questions. All right, at the end. If a prisoner is found with a cell phone, can we search it without a warrant? He's in prison. Okay. No right to privacy. Yes, it's contraband. Yes. If he's in prison, I would think so. Okay. Okay, this is from an officer in Nevada. So I attended your search and seizure class last week in Henderson, and thank you for the experience. You are the best thing that ever happened to me, and you saved my marriage. Wow, I'm taken aback. Okay, maybe I threw that last part in. I asked you about searching an illegal cell phone from an inmate. Now, typically, our practice is obtain a search warrant before going through the phones, USB devices, memory cards, and so forth, right? Now the officer, in one case, I have an officer who recovered a phone and started looking through a call log, took photos of the numbers dialed, And colleagues are saying that this is possibly a Fourth Amendment violation because you had no warrant when you're looking through the phone. And imagine that we find, child porn, escape plans, some issue involving another corrections officer who is bringing drugs into the jail, prison, and so forth. Now what, right? Can that evidence be used? The officer says, I did not feel it was a search or Fourth Amendment issue because the suspect is an inmate. He's lawfully confined in a prison. And as such, he has no reasonable expectation of privacy of anything he possesses and is subject to search by corrections officers. Can I have your expert opinion and guidance on this matter? Okay. So the answer is, this is an easy one. Okay. This is an easy one. I have a case from 2013. This one involved a halfway house, but they used the logic of prisons because the guy was confined in a halfway house. It was the same rules. I mean, even a prison would be even a cleaner case. But whether an expectation of privacy exists for Fourth Amendment purposes depends upon two questions. One, whether the individual by his conduct has exhibited an actual expectation of privacy. Well, okay, look, if the prisoner is trying to hide the phone, right, and it's hidden, has he done what he can to keep his stuff private? Can we at least give him that? Is that a yes or no? Right? I mean, is he doing his part? Is he, trying to keep his stuff private? Yes. I think he's gonna win that part of it, right? There may be debates on this, but I think, okay, fine, give him that part. And whether the individual's expectation of privacy is one that society is prepared to recognize as reasonable. Now, what do you think about this? Do you think that what he's expecting, let's say the court says that he expects privacy. Is he expecting something that's reasonable? Yes or no? Bryant says society would say no. Tyler says, I don't think this applies per se because California versus Diaz kind of applies. I've been curious about this case anyway. The case says that a cell phone is like an article of clothing and can be searched incident to a lawful arrest. That just doesn't seem the same to me. Are you talking about, is Diaz talking about a routine arrest of a free citizen? Tyler, do you have a case? Do you have the case name on that or the citation on that? Are you talking about, is this a prisoner or is this a free citizen? Tell me about that part. Okay. And while you're looking for that, Tyler, hopefully you have some. Oh, that goes against Riley. Is that case old? Is that case before 2011? Hey, my search and seizure instructors, when was Riley, was it Riley versus California or Riley versus US? I think it was California. When was Riley decided by the US Supreme Court? Let me see, 2014. Well, Riley was 2014? Okay. So hold on real quick. Let me just kind of, let's change views here. So, by the way, I love aele.org. Do you guys know about this, right? aele.org. The website, my friends at AELE, and I've been taking all their classes. I wish your website was a little better. I know you guys are working on it. It's a little hard to navigate, but I still love your material, and I think you guys are great over there. Yeah, Tyler says it's kind of old. Yeah. Yeah, this is old. This is not good law. This is definitely that a cell phone is found on a custodial arrestee, incident to a lawful arrest, no search warrant is needed. That's not going to be the case. That was over. So that's 2011, right? And then you got your term of 20, it decided in 2014. Riley overrules that. Okay. So there you go. That's not good law. Okay, cool. See, don't you guys love these trainings? We're all learning together. This is awesome. I love it. This is great. Yep. Okay, so even if the prisoner wins on number one, he loses on number two, his whole argument is going to go down the drain, right? Just like number two, because you need both under reasonable expectation of privacy. You need both. You have to have reasonable expectation of privacy in your own brain subjectively, and it has to be something that society would recognize as reasonable. Because Huart lacked a reasonable expectation of privacy in his cell phone or his contents while living at the Rock Valley halfway house, you might as well insert at the prison, at the jail, at the halfway house, right? You might as well just insert the blank there. The search that uncovered the phone and the images stored on it does not implicate the Fourth Amendment. In other words, this is not even a search under the Fourth Amendment. Therefore, we do not need what I call crew. You don't need anybody's consent. You don't need a recognized exception like exigency, okay? You don't need it, right? And as my friend on YouTube says, there is no expectation of privacy in prison, in your contents. Also, not only is there no expectation of privacy, I like to say there's little expectation of privacy. There's some expectation of privacy in very limited circumstances, but there's no expectation of privacy on a certain item known as contraband. So not only may you have little to no privacy interest in your items in prison, but you certainly have zero expectation of privacy on contraband. Is the cell phone contraband in a prison? The answer is, or a jail. The answer is absolutely yes. You're not supposed to possess it. So society will contraband. Zero, nada, nothing, right? So therefore, we handle it that way too. This is not a Fourth Amendment search. You can search it with absolutely no reason. Okay, I mess up I pressed something on YouTube. I might have messed something up. So here's the takeaway: prisoners have practically no privacy in their property, including cell phones, especially if the property is also contraband. They can be searched without a warrant. This would violate the PREA in some area. I don't know how that's going to work. The PREA, I forget what that stands for. It's the Prison Religious Environments Act or something like that, right? Isn't it something? But I don't see how that I mean, what I know about that law that Congress passed, basically that prisoners have some religious rights, and when you make decisions and so forth. But I just don't see how that can violate a prisoner's rights. They don't have a right to a cell phone in a cell. So I don't see how that comes into play. All right. What do you have any other questions for me? Right. I would love if you guys have anything, Anthony, I had this case, okay, copy on that. Oh, I see. Right. I see what you're saying. You're saying that somebody else's comment saying, no, that what they're doing would violate the prison rules. I got it. Guys, you can also put in the chat here. Okay, so Jesse says, a vehicle is parked on the side of the road, broken down. No person is or around the vehicle. The out-of-state tags are expired. The VIN plate is mostly covered with a cigarette wrapper, so only the first couple of numbers were visible. Can you open the door to check the VIN? Okay, what do you guys think? What do my search and seizure instructors and my fellow officers here think under these facts? Andrew, let's say no. Oh, and also this is Jesse. I didn't go to everybody. I'm going to resend to everybody. Oh, the door was locked and a tow truck driver was called to open the door in order to see the VIN. Is that correct, Jesse? In order to see the VIN. Okay. Let's walk through this. Okay. So let's walk through this. Number one, does a person have a reasonable expectation of privacy on their VIN, right? The VIN that's in the on the dashboard. The answer is no. That is New York versus class, right? Right. New York versus class. In fact, let me see if I can bring that case up real quick. I have a quote on that case. So, but does that mean that the cops, because in that case, the cops could not see the VIN, right? And the cop opened the door to move a piece of paper or to see the door placard, and there was a gun found in plain view, right? Now, I do think the law is in favor of the officer. I really do. I think the fact that the VIN cannot be seen, it's, the cop wants to see the VIN to make sure that the VIN, make sure it's not tampered with and so forth. However, one thing that we don't, we have to have a reason to open up the door, right? If the, let me give this to my friends on YouTube too. So one thing that we want to know though, is that if the officer cannot see, can see the VIN. Oh, this is too big, hold on. All right, here's this, I'll give at least the case citation. If the officer can see the VIN and wants to just verify that that VIN is the same as the one in the door placard, that would not be authorized, because you may not have a reasonable expectation of the VIN, but in that New York case, it was because the VIN was covered up. But here's what I would do. Okay, so I think the answer is that it doesn't violate the Constitution. But personally, I would, if I was on scene, I would not be opening up people's doors unless I had a reason to do it, like the VIN appeared to be manipulated or something about that VIN's not coming back to the registered, to the registration. I would have a reason. Okay, I just don't like doing stuff without a reason. I don't like doing stuff just to make sure. I guess make sure. Do I believe it violates the Constitution? The answer is no. Okay. Yeah, exactly. Okay, Maryland decriminalized marijuana and paraphernalia involved in the possession or use. I'm on federal jurisdiction. We used to assimilate state law for paraphernalia, but no longer. Marijuana is still illegal on federal jurisdiction. Does the marijuana paraphernalia still give me any PC to search for the drug if it's used or possessed or being marijuana? Hold on. Give me any PC to search for the drug it is used to possess or is used being. So I know this is marijuana since it is legal in federal jurisdiction. That whole assimilation issue is beyond my pay grade. Some places do, some places don't. You have to look at your regs on that one. However, when we have cops on VA property, my BLM, my Rangers, my forest officers, all those cops that are on federal property enforcing federal law, marijuana is illegal. And we know by the U.S. Supreme Court said that the feds can still, and this is a case, I forget the exact case name. I can get it for you if you want, but the U.S. Supreme Court said that the feds are still permitted to enforce marijuana law, despite the fact that the state has decriminalized it. So if you have a regulation on it, you have a law that they're violating, generally speaking, it's constitutional to enforce it despite them being able to possess it off property. I hope that answers your question. So somebody on YouTube says, does the paraphernalia itself get us into the vehicle? If the paraphernalia is illegal under federal law, you got to, I'm not sure how I can answer that, because you guys are saying that you're assimilating state law for the paraphernalia, but But you could cite for that paraphernalia, if that is a crime under federal law, then the answer to me would be yes, because you would look for the drugs that go with that paraphernalia. I think the answer is yes. But if what you're seeing is paraphernalia only, I would probably lean towards no, unless you have a reason to believe that there is marijuana currently in that vehicle. YouTube, if a driver advises he has no weapons in the vehicle and you observe a fixed blade knife on the passenger floorboard, does the vehicle frisk apply? The answer is yes. In fact, you're almost kind of giving me the facts from Michigan versus Long, which is a U.S. Supreme Court case involving a knife. The officer in that case saw a knife in the mat pocket of a driver's door, and they searched it frisked it, whatever you want to call it, did a protective sweep, whatever. They did a protective sweep for more weapons and found narcotics in the center console. And the U.S. Supreme Court upheld that. So the answer is yes. Now, here's the deal. The rule for protective sweeps under Long is armed and dangerous, right? Do you believe they're armed? The answer is yes. Do you also believe that they could be a danger? Most courts are going to give you a lot of leeway here to seize a weapon, knife, gun, even if lawfully carried during a traffic stop. The vast majority of court cases out there say that having a weapon does make you dangerous. And I do obviously tend to agree with that. However, what we're teaching in 2020 and beyond is don't go into court and just be like, yep, Your Honor, if they got a gun, I can seize it as a matter of, routine. I don't need anything more than that. If they have a knife, I can seize as a matter of routine. So if the guy has a van full of, he's a knife salesman, you can seize every single knife in his van, as a matter of routine. The point is just have a reason, right? You're going to do FSTs on him, standard field sobriety tests on him. You're going to get him out of the car. You want to make sure he has no more knives on him. I think you're going to be fine, but I just like having reasons. Anything else before we wrap up? God, why am I going blank on McLeod? John, is that the one from? That's the one from Vegas. Oh, what is that? Is that a real case? Oh, it's part of your. I'm sorry. I'm sorry. Which one is the? Remind me what the point was on that one. What was the little parentheses? Entry onto the property. Yeah. Okay. I think the issue was, if I have my facts correct on that case, wasn't the issue the raccoon case? What, right? That was the raccoon case. Okay. The issue there was that they got onto the property lawfully. They saw the raccoon as a pet lawfully, right? But then they brought in basically animal control back onto the property and seized it. There was no agency to call in other people and to come back onto the property to seize that animal. You would need a recognized exception, either consent, agency, a warrant, and so forth. And that was the problem, I think, in that case. So they just talk about how curtilage is protected. It's not treated like open fields. Even if cops have probable cause that there's evidence on curtilage, John is like, keep going, I'm talking. Even if cops have probable cause that there is, evidence on curtilage, you still have to have a lawful reason to be there. And again, if I have my facts correct on that McLeod case, they left that property. They left it. So they pretty much lost their exception to be there. Exactly. And they came back multiple times. Exactly. So it's just the takeaway there is don't forget the power of curtilage, don't violate people's curtilage. All right. Yep. And I can never, my friend on YouTube says, thanks, Anthony. Always good information. And I can never learn enough. I feel the same way. I can never learn enough myself. I'm always learning, trying to make the best decision and so forth. We're going to leave it at that. Okay. We're going to be done for the day. Guys, thank you so much. Happy holidays. I'll hopefully see you guys next week, right? Just real quick. Hold on. What do we have? Let's see what we have next week. Hold on. Do we have anything next week? I think we do, right? Let me just give you guys the so you can see the website, bluetogold.com. We kind of change things up a little bit. Free training. And next week is, well, December 5th. I guess I'm going to take a little bit of break off. Next week is traffic stops and canines. So there it is. And let me give to my friends on YouTube. All right. All right, guys. That's it. God bless. Merry Christmas. Happy holidays. And I'll see you guys next year. We're out. Thank you. I appreciate it, guys. Thank you. I really do appreciate it. Thank you. Hopefully I'll see you guys in the live classes too.